Good morning, everybody. Thank you for joining us today for Ashbur's June webinar. My name is Amber Hines, and I'm the owner of Ashbur. We specialize in Medicaid compliant annuities, specifically annuities from A-rated insurance carriers and short-term annuities. And today I'm super excited to have attorney Matthew Parker, who is a certified elder law attorney in the state of Pennsylvania. He's going to be talking about aid and attendance benefits. Some of you probably haven't done a whole lot of aid and attendance planning since the rule change in 2018. So Attorney Parker is going to be talking about the eligibility requirements and the different ways that we can plan for aid and attendance benefits. If you do have questions during the seminar today, feel free to type those into the questions tab of the GoToWebinar dashboard. Also, if you're interested in a copy of the handouts from today's session, you can find those in the GoToWebinar dashboard as well. And I will go ahead and turn it over now to Attorney Parker. Thank you.
Okay, thank you so much for joining us today. As she mentioned, my name is Matt Parker. I'm an attorney in the small town of Williamsport, Pennsylvania. We're an elder law firm. We do a mixture of Medicaid planning, master protection planning, as well as the occasional, VA benefits planning for our clients. As we'll talk about here today, there are some new rules that came up not too long ago that made planning a bit more challenging. I've seen aid and attendance benefits used an awful lot throughout my career, and they do help our veterans help preserve assets once they need to qualify for aid and attendance, and also become eligible for the program. And if you've been practicing as long as I have, you may remember that the rules for qualifying for this program were fairly lenient in the past. Most veterans could get eligible without much effort. We didn't have to do a lot of aggressive planning to get them eligible, to get them to the resource limit that the veterans once had, which was a fairly, very vague $80,000 at some point. But since 2018, they've implemented some rules that are very similar to Medicaid, making qualification for this program a lot more challenging. So with that, we're going to give you sort of the 80,000 foot view of this program. This is a pension benefit. It's a monthly amount of resources that are given to the veteran, or in some cases, the widow of the veteran. Typically, in our cases in dealing with the elderly, we are looking at a pension for people who are in assisted living, or maybe they're at home and they're paying a lot of out of pocket for home-based care. Occasionally, you might see it in a skilled nursing facility to help defray the cost of care if they are paying privately. Those are the contexts in which we typically see this benefit. And you're seeing most of these applicants need help with some sort of activity of daily living. 2 out of 5 of these, much like in our other contexts, they need assistance with. There's also been some expansion of this need for help with the activities of daily living under the rules in 2018. If you need help ambulating in the home, that's an activity of daily living. And for those with dementia, if they need constant supervision, even though they might be able to perform these activities, those people with dementia would be covered under the aid and attendance benefit. Even though they may be able to do a lot of those activities, the dementia is preventing them from being independent. So the pension benefits are often referred to as an improved pension, and there are 3 levels. 2 out of the 3 of these I just never deal with, probably because I don't have a client base where you're getting a low income benefit. But you should be aware that they exist. The low income pension is for veterans who need assistance, typically meeting their monthly expenses. It's designed basically to bring the vet's income levels up to the limit established by the VA. And then there's this housebound benefit. basically it's an add-on to the low-income pension. It's available for vets and widows of vets who meet certain criteria. Typically, they are disabled and they're confined to the home. Those individuals over 65 are presumed disabled, and they need only to prove that they are confined to the home. And the definition of being confined is not as strict as you might think. They might be confined even though they're able to go to the doctor's office or attend church services. So there is a definition in the program about what constitutes housebound confinement. But it's intended to help veterans live in the household. But most of us who are elder law attorneys are dealing with the aid and attendance benefit. That's what we're going to focus on today. And there are some general eligibility requirements for the aid and attendance benefit, as well as these other pensions. So your veteran has to be discharged from service other than dishonorable. I haven't come across somebody who said it was discharged dishonorably. Maybe it will happen in the future, but almost all of them have their discharge papers somewhere. Most of them can acquire them at some point. They have to serve during what they call a wartime period. And I don't have the dates on one of these slides. You can always look them up online if you want. But for most of us, it's now dealing with Korean and the Vietnam War. There's actually 2 time periods in the Vietnam War where you might be eligible. And the next is the Gulf War, which started in 1990. So we're dealing with younger service members. That 1990 period goes on seemingly currently. It continues to go on. So you've got wartime period. They have to have served at least 1 day during that time frame. So you ask them, when were you serving? And if you can get 1 day of service, even if it was stateside, during that wartime period, they meet the criteria. And the active duty requirement is 90 days. Now, I will tell you that if you happen to deal with younger people, they've extended that 90-day requirement to 24 months. So if their service period was after September 7th of 1980, there's a 24-month requirement for those younger participants in our armed services. Then there's a medical need benefit that everybody has to meet. Most of our clients meet the age 65 years of age or older requirement, but there's an or here in all of these cases. You could be permanently or totally disabled. You could be in a nursing home or a long-term care facility because of a disability. You could also be getting Social Security benefits. And 2 that I don't have on this slide that just rarely come up, but they show up in most of our benefits. You could have a visual impairment. You could meet the definition of blindness. And you could also be bedridden. That's the other one that doesn't show up that often because most of the time one of these other requirements applies. So you're going to probably be focusing on these financial tests for eligibility for your aid and attendance applicant. There is a net worth calculation more clearly defined under the new rules in 2018 as to how your client is going to be eligible for benefits, and it's going to be including not only the assets that are countable, but also the income of the applicant. They're married, also the income of the spouse. And it changes year to year, much like our Medicaid rules. The veterans do change their numbers on an annual basis. In conjunction with the net worth calculation, there is a review of your asset transfers within the last 3 years. That's one of those changes that arrived post 2018. And lastly, there's some income limits. It's basically an income analysis to determine how much aid and attendance your applicant is going to be receiving. The unreimbursed medical expenses, such as the cost of caregivers or maybe assisted living expenses, are greatly going to reduce your countable income, and that's going to make most of your applicants eligible for a sizable amount of the VA pension. All right, so the net worth calculation. Right now, we have a net worth limit of $150,000. Again, it changes every year. So in November of this year, it will expire. They'll come out with a new number. It includes both the countable assets and your gross annual income. The countable assets include the net value of non-exempt property that claimant has the ability to liquidate. And there aren't as many exempt assets as you might find in the Medicaid program in the VA rules. So the annual income includes both the spouse's income, as I mentioned, and that usually includes the Social Security, investment income, and retirement payments for either of the spouses. Countable assets, just basically anything you can liquidate, from the cash and the investments, even the cash value of life insurance, IRA values. They don't have as many exemptions as you do with Medicaid. So the exempt property, the largest of which is the primary residence in a reasonable lot area, and they define that as 2 acres unless the additional acreage is not marketable. This is a big part of the VA rules that were changed in 2018. I know in a lot of these cases, you need a statement that your additional lot acreage is not marketable for various reasons, maybe subdivide. I think the VA is fairly reasonable with regard to this. If you got 3 acres instead of 2, they don't carve it up. I have not had a lot of farms or situations where you have much greater acreage than this 2 acres, and you have to sort of analyze, well, are you eligible for the program or not? So I'd be curious if if we have practitioners who are in areas where this lot acreage becomes an issue, how they're able to reduce that value or make the argument that it should not be counted in this calculation. Burial counts, from the very beginning, there was always a question whether burial counts were exempt, but that's why the question mark is there. But from my experience, they are treated as exempt accounts, and they can be legitimate spend downs as well. Here's a simple explanation of how they determine the net worth. Countable assets plus your annual gross income, plus your unreimbursed medical expenses. So I didn't put the UMEs in this example just to keep it simple, but if your countable assets were under 20 grand and your annual income was another 20, your net worth would be 40, and of course that's less than your 150. So that's an oversimplified explanation of how they're doing this. But the UMEs are very helpful, not just in terms of reducing your countable income for the purpose of this calculation, but also when you get into the income analysis to determine, well, how much are you going to get from the VA every month towards the cost of your care? And those UMEs are going to come very handy. Here's a big change from 2018. Unlike in the Medicaid program, we have a 36-month look-back period. And the gifts are only for what they call covered assets, which is very different from the Medicaid concept. Covered assets are those that would be counted to determine your eligibility for the VA benefits. So an exempt residence, for example, or resources that are much less than your net worth. Well, let's put it this way, that your net worth is not in excess of their 159,240. The current net worth figure, you only have 140,000 and you gave away 20 of that. Well, you didn't have to give away that 20 to become eligible, so they're not going to penalize you for that. Very different from Medicaid. Same thing with that transferring the house. So the house is exempt. Now, did that in the Medicaid context, you would be ineligible unless you were transferring it to a caregiver child or a disabled child. You have a problem with transferring that house. But in the VA's world, not a problem. So you have to determine your client's net worth, first of all, and add back in those cash gifts within the last 3 years and determine if that total is in excess of the net worth. But the time frame for determining when this penalty has run or expired is also different from the Medicaid program. But we do initially, count up those transfers, and then we have to figure out when they were made. to determine the ineligibility period, which gets us into how is that calculated. So you have to figure out what the maximum annual pension rate is and divide that into the penalized gifts. And that's the maximum amount they're going to give under their current rules. And yeah, every year they change these numbers. You can go online to figure out what they are. The maximum pension rate is $27.95 per month. That's for a veteran with a spouse. And the penalty begins to run the month after the transfer is made. So this is a hugely different concept than the Medicaid system. The Medicaid system says, well, you made a gift within the last 5 years. We're going to run that penalty at the time you're eligible for benefits, but for the transfer. So they tack it on when you've otherwise spent down. It's a rather punitive concept. But the VA operates like the Medicaid program used to operate. You know, the penalty begins the month after the transfer was made under these new VA rules. So you could have given away a large amount of money, 2 years ago, and that penalty may have run out. Now the divisor is relatively small in this case; it's only $27.95, so keep that in mind. But gifts the penalty period associated with a gift made 2 years ago may very well have expired by the time you're applying today. There is a 5-year cap on penalties. So take your $27.95, multiply that by 60 months, you get the maximum amount that you would transfer and affect your eligibility. It's similar to the 3-year cap, I think, for SSI purposes. There is a point at which they're not going to extend the period of ineligibility. Unlike Medicaid, fractional months are dropped off. So when you figure this time period out, you're going to drop that fractional month. I have an oversimplified example here, $10,000 where the gift helped reduce the net worth at time of application. So you would have had to have $169,000, less your $10,000 gift brought you in line with the gross net worth. 6 months, however, before the application was made, you made this $10,000 gift. So you take the 10 grand and develop by the $27.95. That's 3.5 months. You drop the half month, and so you got a 3-month period of ineligibility. But it started running the month after you made the transfer. So the penalty would have expired in my example here because 6 months has gone by. So some of these small gifts that you're going to find in your applicant's records, you're going to drop off. Christmas gifts, birthday gifts, and so on. They're going to be so small they don't affect them at all. I am unaware of a rule in the VA system that says, yeah, you make this gift for a reason other than to qualify for benefits, and therefore we're not going to count it in terms of determining whether it's a penalty or not. We have that part of the rules in the Medicaid program, but at least the VA may have it, but I'm unaware of it being written anywhere. So you've just got to keep in mind for most of these smaller gifts, you're not going to have an issue at the time of application. There's an opportunity to cure, partial or total cure. They actually spelled that out in the rules. You can return the funds before they came 60 days of the notice of the penalty. And you need to get evidence that the money has in fact been returned. Immediate annuities as gifts. Well, thanks to Ashburn for putting this on, but I have to tell you all that annuities, while they used to be great tools for helping veterans qualify for aid and attendance, the VA has cracked down on the use of them in the VA context, that is for aid and attendance. We used to take all these excess resources we had and turn them into immediate annuities and reduce the overall resources the veteran had, and voila, the veteran was eligible for benefits. At least turning that immediate annuity into an income stream may have raised the amount of income they had, but it reduced the overall resources, and it did help us get a veteran eligible. Now, we're not talking about deferred annuities in this case. For those of you who don't deal with annuities all that much, those deferred annuities can be liquidated and they can be counted in the the overall net worth as a resource. But we're talking about immediate annuities where you're paying a premium, a sum of money for an immediate insurance product that's going to start paying probably the month after you purchase it. These don't have cash value. And basically, in the Medicaid context, you're converting resources into an income stream, and they work very well in states that allow community spouses to purchase these products. Basically, what happened is a big industry arose with these annuities, with more than just elder law attorneys who were using them to help veterans to qualify. And the VA decided to do away with this planning in the 2018 rule. So if you do acquire one of these annuities with covered assets, the amount, again, that's above the net worth is treated as a gift that was funding the annuity. Now, keep in mind that there's going to be a period of ineligibility or penalty period associated with this. How long is that penalty? All of that has to be factored into this to determine whether the purchase of this product affects eligibility. You can still buy immediate annuities for Medicaid purposes, but be careful for the VA. It is a transfer, and it applies to the spouse as well. So if you're doing spousal planning, keep that in mind. I should mention the irrevocable trusts when we're talking about gifts. Irrevocable trusts are counted. If there is any scenario where there are retained benefits to the settlor, your applicant, or the spouse. So we used to see older irrevocable trusts with retained income, and for as long as I remember, because the rules regarding trusts have been around for some time, we haven't retained any income rights for the veteran if we're using irrevocable trusts. Transfers to an irrevocable trust can result in a penalty. Again, if you're using covered assets, if you're doing a house, well, the house isn't a covered asset. So a lot of planners are, in fact, transferring the house to one of these irrevocable trusts. But some practitioners are trying to avoid the imposition of any income tax consequences on the veteran's tax return out of fear that the VA will flag these trusts and wonder, why is this grantor trust producing an income benefit to the settlor? And so they create a concept where the grantor trust retains the grantor rights over the home and allows you to get the benefit of exemptions from capital gains taxes. And then that trust distributes the funds to a non-grantor trust, and then all of the income benefits from that point forward are taxed to third parties like children. So there's a two-tiered trust concept that goes on in some of these planning cases. You just want to avoid having one of these trusts flagged by the VA. So if you're going to use grantor trust for planning, make sure your local VA is not going to flag your trust. Talk with your representative down there and make sure you know what the rules are. My experience over 25 years is that one of my trusts was flagged for a reason. I don't remember what it was, and I'm convinced it goes to some dark room in the VA office somewhere and gets stuck on a pile with all these other trusts that were flagged, and you never see the light of it again. Because I never did, and I never knew why they flagged it, but it happens. And so if you can avoid getting one of your trusts flagged, great. Just make sure what the rules are in your region before you start using them. So the income test is the last test you've got to be aware of. Basically, you're going to be denied benefits if your countable income exceeds that maximum allowed pension rate. All income received by the applicant is countable unless it's specifically excluded. And again, it will include the spouse's income as well. Here are your typically excluded income, welfare benefits, refunds, IRA interest. That's what's being earned in the account itself, and your loans and reverse mortgages also exempt. Income deductions, here's where we can do a lot of good planning for our clients. Make sure you have a lot of unreimbursed medical expenses. that will reduce the income. So countable income can be reduced by these unreimbursed medical expenses that are paid by the vet or the spouse. Neither the vet or the spouse were reimbursed and incurred by a member of their household. They, for example, include your Medicare insurance premiums, including supplemental insurance, fees paid for in-home care, assisted living care, as well as nursing facility. Other services might include dental services, as well as physical items you could be buying like hearing aids, wheelchairs, crutches, and other items like that. Income formula, basically you're taking your maximum pension rate, you're reducing it by the countable income. That plan, of course, is to reduce these countable income increase your monthly benefit you're going to receive from the VA. So if you've got assisted living, it might be well in excess of your client's they can provide. Unreimbursed medical expenses, here are the common examples. A lot of clarification in 2018 rules, if you want to take a look at them, as what expenses were deductible. Proof was needed to confirm that the activities that they were part of their care. In some cases, it's easy to establish. In other cases, you might need a physician's letter if the care was being provided by someone who wasn't licensed to determine whether or not they meet the definition of the ADLs. They had also expanded who could provide this statement. I know in a lot of cases, the care facilities are just providing the statement that the client needs to be in a protected environment. But you got a physician or PA and nurse even provide statements. Check to see what's needed at your local VA. Most of the facilities I deal with, they know exactly what's needed. They're dealing with the VA all the time for these applications. So there's also a 5% deductible for unreimbursed medical expenses. Basically, you have to pay out of pocket up to a certain limit before the unreimbursed medical expenses will reduce your income. So you got a single veteran example here. The mapper for a single veteran right now is 28.3, $30,000 worth of countable income. You got a medical expense deduction of 12 grand. 5% deductible. Again, sometimes these are on charts. Your medical expenses, and you get, and you take that off of your income, and that's the amount that you're going to reduce from the maximum allowable pension rate. Then you get a net, and that's how much you're going to get from the aid and attendance benefit. Now, I will tell you, this example is not what I normally see. Normally, I see clients with very high unreimbursed medical expenses, and we get very close to the maximum aid and attendance benefit. This gives you an idea of how the numbers work for purposes of your own calculations. Planning with excess net worth. Here are some examples for you. I'd mentioned there's a 36-month look-back period, so transfers outside of that. If you're doing planning not just for VA but for Medicaid, you got to keep in mind you got a 36 for VA, another, 5 months for 5 years rather for Medicaid purposes. So you overlap, figure out which one is more beneficial to you. The interesting thing about the 36-month look back period is that your period of ineligibility is running. You may very well outrun it. That's not something you have with Medicaid planning. There's an idea out there with a lot of this planning that you might do the old half a loaf gifting, where you're making a percentage of a gift to a person or to a trust, and then you're paying down the other percentage on caregivers or assisted living. So you're trying to get through the penalty, if you will, by paying for a person's care. It's a concept we still use a lot in Medicaid when we're doing gift and annuity planning. But that's an idea that's out there for veterans planning as well. I mentioned transferring of uncovered assets such as the house, spending down, big part of the planning. Caregivers are often part of the spend down, but you can also spend on goods and services, upgrading the house, Funeral expenses, to my knowledge, VA allows that. Purchasing a life estate in somebody else's house, you don't have the 1-year residency requirement for that. So the VA, to my knowledge, permits you to purchase a life estate interest in someone else's house, provided it's going to be your primary residence. So, and by the way, if you sell the house, you have a 1 year to purchase another house, or in this case, maybe a life estate. There was a time frame there to when you sell the exempt home, you want to purchase another house within that time frame that they allow. Be aware, there's an overlap with Medicaid, so you got to be careful that there are 2 different types of rules out there. Try not to get them confused. That brings me to the end of my presentation. I know this was a simplified overview of VA aid and attendance benefits. Those of you who are specialists in this area, you're familiar with all these rules and then some, but this gives people who maybe dabble and maybe not quite sure what the rules are, or the simplified explanation of what we're dealing with. Trying to counsel our clients about whether they're eligible or not for this program. And I always have a good relationship with my local VA rep to make sure I'm not running afoul of something new that's come up that they need to advise me about. So I appreciate your joining me today, and I appreciate ASHPR for giving me the opportunity to present.
Awesome. Thank you, Attorney Parker. We do have a couple of questions here if you have just a few minutes. Somebody is asking, can you pick up benefits for a spouse that is in need of care, but the veteran is not?
To my knowledge, so long as a veteran is alive, no. It has to be a widow.
Okay. Another question here is, can you speak to the VA protection trust being counted if income is retained? Do you mean that they count the income or the income and the assets in the trust?
They count, to my knowledge, what they do is they count the assets in the trust as a resource for determining your net worth. So if you transferred 30 grand to the trust and you thought, well, I've made it through the 36-month look back period, but you retained the income, they're going to count what's in that trust as belonging to you.
Okay. Somebody is asking whether your firm handles appeals for disability claim denials.
No, we don't get into that. We're an elder law firm that deals primarily with benefits for older adults, such as aid and attendance.
Okay. And last question is, can we claim dental premiums as part of the unreimbursed medical expenses?
Excellent question. I haven't run into that. And so that's something you just call up your local VA representative or run it by them, see what they say.
Okay. One last question is, how are claims currently moving through the VA? Is it pretty expeditiously, or are you seeing long delay times?
So this is probably going to be dependent regionally. I could tell you what central Pennsylvania is not seeing extensive delays, but that was before some of the changes down in Washington. So I don't know what's going to come out of that. But I think that question is more of a regional situation. What I might be seeing here in central Pennsylvania is sort of a reasonable wait time. Might not be the case in other places in the country.
Okay, perfect. Well, we appreciate your time today. Thank you, everybody, for joining us. If you have any questions about today's seminar, feel free to reach out to me at Amber at ashpur.com, or give our office a call. Thank you, Attorney Parker, and we appreciate everybody's time today.